Hello, Hey Boomer listeners. My name is Wendy Green. I am the host of today's show, Hey Boomer. And today's show is going to be full of a lot of important information. If any of you have either been an executor or a personal representative or think that you will be at some point, you are going to want to listen very closely to what we talk about on the show. And I just found out something very special right before we came on air. So we will share that with you at some point during the show. But it's another beautiful little coda or add-on that we can talk about as we go forward. Before we get started, I wanted to talk about doTERRA. doTERRA is the essential oils company. And last week, I told you that doTERRA digestive products have really made a significant difference in my life, that I have completely gone off acid reflux medication and am finding eating to be a lovely experience now, which is a real plus. So because I had bought a full kit, I had some essential oils and I decided to play with them. And one of the oils I've been playing with is lavender. So for me, sleep has always been a challenge. It's one of those, I can't get my mind to shut down. I remember even as a child, I would wander into my parents' bedroom, like, I can't go to sleep. Don't go to sleep yet. I'm still awake. And my mother, bless her heart, was probably so tired of me coming in there. And she would say, just rest. Rest is as good as sleep, which is probably not true. Sleep is more restorative, but I would try. So I figured, what the heck, I'm going to try this lavender oil. And I rub it on my hands, just a couple of drops, rub it on my hands, then rub it on my pillow. And honestly, the last several nights, I've been able to fall asleep and stay asleep. So it's something's working. Something seems to be making a difference. So I'm going to attribute that to this lavender oil from doTERRA. And Heidi Woody is my doTERRA wellness advocate. She is committed to educating you and to finding the path for your complete wellness. So you can text Heidi at 864-238-8120. You can drop her a note at her personal link on doTERRA, which is www.doterra.com. And it's really Heidi G. Woody. And you will be able to communicate with her there. So I encourage you, I totally respect what she's doing and who she is and the products that she's supporting. So go check her out. I also want to say, I love it when you all chime in and say hi, even if I don't get an opportunity to say hi back. I love that. And last week we had wonderful participation and questions. So I'm looking forward to a lot of questions that might come up for you as we talk with Anna. One other thing I wanted to tell you about is that I have started a Hey Boomer team for the Walk to End Alzheimer's. This is near and dear to my heart. I've been walking for Alzheimer's for, 7 or 8 years now. And if you are in the upstate of South Carolina, I would love for you to join our team. You just go to act.alz.org/go-to/Hey Boomer, and you can join the Hey Boomer team there. Thank you to Doris, who has already joined my team. If you're not able to join us or you don't happen to be in upstate of South Carolina, you can still donate there. So I've set a goal for the team of $1,000. And please help us reach that goal. Go ahead and donate. If we do really great, maybe I'll bump up the goal because the walk is not until October the 2nd. So go ahead, jump on, be part of our team. We're going to have a good time that day. And with that, I am going to bring Anna on. Hello, Anna.
Hi, Wendy. Thank you so much for having me today.
Oh, I'm so glad you're able to join us because this is really an important topic. So let me introduce you and say a little bit about who you are. So Anna is an attorney and a financial advisor, and she has served hundreds of clients. And through her personal and professional experience, Anna understands that life is unpredictable. She became a widow at 28, and over the years recovered and grew, despite the adversity and emotional devastation she had experienced. Her journey has taught her about the kind of relationship clients need in times of transition and stress, and she offers clients guidance and a strong shoulder to lean on. As a lawyer, Anna founded Byrne LLC, which is a life and legacy planning law firm. And she also founded Kendall Wealth, which is an independent registered investment advisor that offers planning and investment management services. But overall, her goal is to help her clients express and pass along their values, not just their assets, with the lowest expense and tax impact possible in order to create a true legacy. Anna is a member of the Massachusetts and New York bars. She was honored by Lawyers Weekly as a top woman in law in Massachusetts in 2014 and was named super lawyer by Thomas Reuters from 2015 up until today. And in 2016, Anna published a book, The Widow's Guide. And this was to help women who have lost a spouse navigate through their first year. And then in 2021, this current year, she published the Inheritor's Guide. And this is a manual for anyone who has lost a parent and wants to gain an understanding of the step-by-step process of transitioning wealth from one generation to the next. And I would say not just if you've lost a parent, if you have a parent and you know you're going to be an executor. I told Anna after reading this book, I am going to sit down with my mother and go through chapter by chapter and make sure we have everything we need so there's no surprises at the end. So Anna, we like to start by getting to know a little bit about you. And I know I mentioned briefly about losing your husband at 28, but could you kind of recap your journey and how it got you to where you are today?
Yeah, absolutely. Thanks so much for that lovely introduction, Wendy. So I became an attorney in 1994. I met my husband first week of law school. He was also an attorney, and it was really love at first sight. You know, it was kind of one of those things where he was 6'4", I'm 5'2". I looked up and there he was, and it was like fireworks. It was literally fireworks. And I was 21, you know, definitely not someone who was looking for a husband. And that was just not on my radar my first week of law school. But here I was, got married in law school, and just really he was my soulmate and the love of my life. And we were visiting his family in Connecticut one weekend for just a fall cleanup. He kind of came from this family that got together to help their elders clean up in the fall. And so we got there the night before, and the next morning, on a Sunday morning, he took our dog out for a walk, and he never came back. He was shot and killed by a young guy, 21 years old, who bought a shotgun for hunting, but he was on private property on a Sunday morning. And Ron basically bled to death. So that was just the most devastating thing that could have ever happened to me at that point in my life, or anyone's life. I mean, the shock of it and the tragedy of it was just, you know, kind of out of a movie, and left me, you know, obviously alone, but also trying to figure out how to restart my life, and what to do with my life. And, you know, it was an experience, a journey really that took me 3 years to get from, you know, that moment where he died to, you know, meeting Michael, who's my husband and has been my husband for many, many years. And it's really that journey that I have helped so many women through in the last few decades of my career. And so ultimately, I decided to create a law practice that was focused on estate planning. And it was estate planning that was it was about more than just taxes. I was trained as a tax attorney. I was a tax attorney. I am still a tax attorney. And what I found was that estate planning was really driven by the taxes. But what I learned in my personal life is that, nothing prepares you for that moment of just being without your partner, without, the love of your life, the person who you share decisions with. No amount of taxes are going to compel you to do anything. But I realized that most people really are mostly compelled by love, the love that they feel for their spouse, the love that they feel for their family, the love that they feel towards, who they care about. That's really what drives people to take care of their affairs and to do the planning. And so I created my law firm, Byrne LLC, to really help people, motivate people by educating them and about talking to them, not about death, but talking to them about love, so that they could create well executed, holistic, comprehensive estate plans that prepared not just the documents, but prepared their loved ones for what the process would be, with clear instructions and clear guidance as to what's entailed. And that's been the focus of my career for the last I guess Byrne is 12 and a half years old at this point. And the firm has evolved to be focused not just on planning, but the administration of estates. And so I shifted my focus from planning several years ago to develop our administration practice. So helping our clients, and we always were doing administrative work, but it was always a smaller component to the planning side. And so in developing that practice, I worked, directly with clients who are managing their parents' estates, their spouses' estates, their friends' estates, and saw, what that looked like, not just obviously from a legal perspective, but from an emotional perspective. And really in the last year and a half, 2 years, I saw firsthand kind of sibling issues, and specifically dealing with the administration of the last parent to die estate to help the adult children navigate that journey, and learned so much about these dynamics that arise between siblings, that arise in the administration of parents' estates. And it was surprising to me, because I felt like, well, this is just the natural order of things, that, parents die, and then, it's the next, generation taking over that legacy. And I decided to write a book about that experience, in hopes that, as Wendy, you mentioned, someone would read the book before their parent died to understand what is involved, and to even have conversations with their parents to understand what their wishes were, and have parents read the book to understand the kinds of things that can arise between siblings if they're not provided for in their planning.
Yeah. What a story, Anna. And how beautiful that you were able to turn it around, from the horrible loss and grief that you had to something that's holistic and love based and not just tax based. It really kind of taking in the whole person and the whole family. And I know in your Inheritors Guide, there is a lot of, in the chapters, you've had a counselor add some things about navigating the emotional part of it, as well as all of the documentation and things that have to happen.
Absolutely. And I would say that's critical. It was very intentional for me to add Dr. Tolchik's perspective as a psychiatrist and a grief counselor, because the Widow's Guide, that journey, that emotional journey, was really my journey. And what I found, though, is that all the widows that I'd worked with in my career had similar journeys, similar trajectories, obviously different based on age, based upon circumstances, but it's a very similar journey. So I was able to share that emotional perspective in the Widow's Guide, where Both of my parents are, fortunately still alive. I have not personally gone through this journey. I've witnessed the journey through my clients. And Olga was kind enough to really add this perspective, because in interviewing many people for this book, including other advisors, other attorneys, other therapists that work with families, they all indicated that the emotional aspects of this journey were moments in time where they just froze, where they couldn't take the next step. They created delays in the entire process because they did not realize that they were emotionally stuck. They
Mhm.
were caught off guard. And
Yeah.
so I think it's really important to, as someone goes through this journey, is that they are really honest with how they feel. There's a lot of things happening, there's a lot of emotions, and there's a lot of stuff to do. But
Yeah.
I really want people to manage their emotions and understand that they are grieving, and that grief can be manifested in many different ways. So that
Yeah.
knowledge will be empowering, because it will allow you to keep moving and prevent you from getting stuck.
Yeah, I thought it was very helpful as I read through it. So there's a lot to get through, more than we can cover in the time we have. But I pulled out a few things that I want to talk through. And the first, we start at the beginning. Your parent dies and you need to plan the funeral.
Right.
And from what I was reading in the book, you don't always have access to the cash to pay for the funeral right away from your parents' accounts. So how do you encourage people to handle just managing the whole funeral process?
Yeah. So in my practice, we talk about this. We talk to our clients who are doing plans to say, this is going to be the first thing that your child or the executor is going to have to pay for. So in our practice, clients contemplate this, right? There might be a joint account that's established, that's got money in the account to cover those expenses. There might be a life insurance contract that also exists to cover those expenses, where the person in charge might be the named person. But then there's this intentionality that this money is really intended for that purpose, right? So if that's not been done, then I think in reality, what happens is that whoever is going to be in charge, whoever is named, just pays for it and is reimbursed the moment that there is an appointment. Once there is an appointment, so that then there is access to the accounts that the parent had. So it's definitely expensive depending on what the funeral is, but that's an expense that needs to be covered. And fortunately, it is a reimbursable expense once the cash is available. So it's really a short-term kind of bridge financing, if you will, until the moment the person is appointed as the personal representative or trustee, whatever the case is.
And so that starts kind of the documentation. There's a lot of documentation you have to do. But you mentioned until that person is appointed the executor or the personal representative. How does that happen?
Yeah. So, what a lot of people don't realize is that wills, typically, most people refer to estate plans as wills, but sometimes there are revocable trusts that actually are the main documents that govern how an estate is to be distributed and overseen. But let's just stick to the will, just to kind of keep things really simple. So, most people assume that a will is an automatic document. So you draft a will, you file it away in your records, and then the moment a person dies, that will is all of a sudden effective, right? That there is just this magic thing that happens, that you then take the will, maybe with a death certificate, to whatever bank, whatever financial institution, and then they're going to say, okay, great. That's not at all how it happens. So when you have a will, there is a process, a court process that's required in order for the will to be effective, essentially. So there needs to be a person in charge, and the person in charge of a will, of a probate estate, of an estate, is called a personal representative or an executor, yeah, depending on the state that you're in. So The will must be filed with the court, and then there's a court process that usually starts with the filing of a petition, where there's a request made to enter the will into the court, and to appoint a personal representative, and to determine heirs of the estate. So that process of filing the will, filing the petition, seeking the appointment of the personal representative, and determining heirs is a process known as probate. So the court's oversight in this process is to make sure that the will is valid. Right. So just because you have a will doesn't mean it's valid. I've had several cases where the will was determined to be invalid. So all of a sudden, everything that you thought was going to happen didn't actually happen. But the court is really responsible for checking the boxes to make sure that the will is valid, that the person named is the person who's seeking the appointment, and that notice is given to all of the interested parties. So anyone named in the will and any heirs at law are properly notified as to the filing of the will and the petition to probate it. So depending on the state you're in, there's this notice period within which someone can contest. They can say, nope, I have a newer will, or nope, I don't want Susie to be the personal representative. Mom said I should do it. That's all happening through this probate process. And ultimately, the probate process includes an inventory of the estate, and then an account of the estate, and then a final settlement of the estate.
Wow. So even though, like, I have my will and I say my son is this and my daughter is that, and who gets what, it still all has to be validated by the court.
Well, it not only has to be validated by the court, but the court actually has to issue a letter of appointment that then is that document that proves your authority, that you are the personal representative in charge. And there's a seal on it, and that is the document that you need to bring to the bank, to the financial institution, to anywhere where you are representing that you are the person in charge of the estate.
Oh.
So
And
the
I
other
imagine
thing,
that takes some time.
it depends. In COVID days in Massachusetts, where we are in Middlesex and Suffolk County, it would take months. So definitely an issue. Some courts are a lot more efficient around the country, I would hope, I've heard. So it just kind of depends. The other thing that I want to point out that most people don't realize is that sometimes the person who's the named personal representative in the will has also been the power of attorney.
Mm.
Right. And so the power of attorney is a document that appoints a person during your life to be the fiduciary, or the person who is able to make all financial and legal decisions on your behalf. But the moment the principal, the author of that document dies, that power of attorney also dies. So the person named as the agent under the power of attorney no longer has authority to act on behalf of the person once they die.
Mm-hmm.
Okay, so until that appointment by the court is issued, there is no authority for anyone to access the deceased individual accounts or assets.
Yeah. And so Doris has a question. Kathy makes a good point, though, also, because when you're going through this, and you talked about how grief can freeze you, Kathy says, yes, grief can indeed manifest in many different ways. I've always believed that while you can delay grieving, you can never escape the grieving process. So here you are suddenly having to deal with the courts and you're grieving. Yeah, that's got to be tough.
It is tough because, the thing is, the process needs to keep moving,
Mm-hmm.
because the starting point is really just this appointment, but then you actually have to shepherd the assets that were in your parents' estate through the probate process. So that means any account that was owned by mom, any the house that was owned by mom, whatever mom owned individually in her name, if it didn't have a beneficiary associated with it, has to be retitled to the name of the estate put under the tax identification number of the estate, and then finally distributed per the terms of the will. So
Yeah.
you have to keep moving, because otherwise everything will grind to a halt. And this
Right.
happens all the time.
Yeah. And so Doris's question was, what reasons might render a will invalid? Did you hear my question?
No, I
Anna.
didn't. You froze for a
Okay, so
moment.
Doris said, what reasons might render a will invalid?
Oh, so lots of different reasons, but the ones that I've seen, the ones that pop up, is that it wasn't executed correctly. So in our state, you need two witnesses that are unrelated to the testator, the creator of the will. So if you have two people that are named in the will, so say the two kids were also the two witnesses, that's an invalid will. That's a pretty common thing.
Okay.
Or the
There's,
will was written on. People scribble
oh,
things on wills that would invalidate a will.
yeah, you can't write on the original.
No.
This is a question I was going to ask you too. Randy Vogenberg says, does the revocable trust alleviate the delays and the process mentioned if just a will is done? And you do talk about revocable trusts in your book.
I do. And this is very state specific in terms of, how your state works. But yes, a revocable trust can circumvent the probate process, in that a revocable trust is a document that's created during the trust maker's life, and it's revocable by them during their life. And the revocable trust is really a chronological set of instructions that apply to all of the assets that are owned by the trust. So what happens while the trust maker is alive, what happens when the trust maker is incapacitated, what happens when the trust maker dies, who is entitled to the distributions from that trust, but who is in charge of the trust, right? So who is the trustee during the trust maker's life? Who is the trustee during the disability? Who is trustee after the person dies? And that is all governed by the trust document. The court is not involved in overseeing that process at all, unless there's some sort of dispute, but generally it's a completely private process. The revocable trust is not recorded with the probate court. So it is really kind of this process that you're creating outside of the court. But it is highly contingent on making sure that the trust is funded, right? So funding the trust means that you've actually transferred ownership of your individual assets to the trust while you're alive as the trust maker, so that then those assets are just going to follow the succession list of trustees, depending on what stage the trust maker is at, whether that person is alive, whether they're disabled, or whether they're deceased. So very important. There's a lot in my book about kind of funding a trust. There's certain assets that you never, ever, 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 ever put in your trust. You never move retirement accounts, for example. You never move those assets into a trust. But individual accounts, bank accounts, investment accounts, real estate, things like that, you fund into the trust, and then you avoid the probate process. What I see many, 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 many people have are the wills, and then they have the revocable trust, and they come in very happy that they have this structure in place because they're going to avoid probate. And when we sit down to discuss what the trust actually owns, they kind of look at me and say, well, it doesn't, I'm not sure. I don't know. What does it own? And so I explained to them that really you're not avoiding probate if your trust is not funded with assets. There needs to be an alignment of, when you're creating your estate plan documents, the attorney is also looking at your assets to determine how the ownership should be managed, whether it's owned by the trust, whether there are beneficiary designations that are required. It is an incomplete estate plan if you have just a will And just a revocable trust, unless the trust is actually funded according to what your attorney recommends as appropriate to carry out the terms of the trust.
So I had always heard, Anna, that if you don't have a large estate, then it doesn't really make sense to have a trust. But what I'm hearing you say, I think, is that as long as you have assets like a home, like a car, like an investment account, having a trust might be a really good idea.
Oh, absolutely, without a doubt, because it allows you to circumvent the probate process. But again, this is state specific, so there may be states that work differently. I know California works a little bit differently than we do, but these are the things that you need to understand how they work in your state. But in our state, in Massachusetts, we really rarely draft just wills, because our clients have really kind of two primary goals. One is to maintain privacy, because whatever you record in the probate court is public record. So anyone can find out what the will said, which is why, when Prince or whoever dies, immediately the journalists know, well, what kind of estate plan did they have? Well, because they just go to the courthouse and look at the will or look at the filing. And so there's a lot of disclosures that are made as part of that process. So our clients generally want to maintain privacy. And then secondly, they want to avoid kind of the time and the expense associated with the probate process, because there are sometimes delays with the appointments. So if you could avoid waiting for an appointment and just have a new trustee certificate or an acceptance of a trustee as listed in the trust done in 5 minutes, you don't have to wait. You're all of a sudden now just the person in charge, and every institution that has an asset owned by that trust now is accountable to you as the trustee. There's a third reason why I think revocable trust also work, and that is, in situations where there is some sort of estrangement, right? Anything that's public, is just, you have to give notice to everyone.
Uh-oh.
Wendy, are you there? I kind of
Yeah, you
lost you
froze for a
for a
moment
moment. I
too.
don't know. Yeah. So there's a third reason why sometimes revocable trusts are also an advantage, and that is when there's a possible kind of family estrangement where, when you file the will for probate, there's an opportunity for someone to contest it, whether they just don't want you to serve, or that they just, they just take issue with it. They want to undermine the whole process. If you don't have to go through that process, there's an advantage to also keeping it private, so that only the people listed in the trust would know about the trust terms potentially.
So that leads us into that whole discussion of potential sibling rivalry and what could happen. And, you had mentioned in your book, which made me a little uncomfortable, I have to say, reading it, that as the personal representative, you're responsible for everything that's now in the house, in the will or the trust or whatever. So you suggested changing the locks, changing the garage door code so that people can't get in and just kind of take what they think they might want. I read that and I thought, oh my gosh, I mean, if I was to do that, my brother, and probably my sister too, but my brother for sure would be very upset that I suddenly locked him out of mom's house. So how does that build trust or confidence and not erode trust or confidence?
Well, I think, there's many reasons to change the locks. I mean, there may be other people besides, your brother and your sister who have keys to the house, whether it's a healthcare aide, whether it's a housekeeper, or whoever. There may be other people that have access to the house who might go into the house now that it's vacant. I think, the experience that I've had is that, if you communicate why you're doing something, the less likely it's going to be construed as anything malicious or hurtful. So here's how I would approach it, because I've seen things walk out the door and then there are pointing fingers, whether the other person took it or they didn't take it and someone else took it. Like, this is what you want to avoid, is this possibility of even having any conflict about it, here's what I would say. I would say, look, brother, sister, mom has died. I really want us to go through this process together around the things. I don't ever want you to doubt what I'm doing. And I want us to have a controlled process so that, when I'm going to the house, I will let you know when I'm going to the house. I will have the key. We can go to the house together. I want to manage this process in the way that works best, because what I find is that this moment of grief, oh, mom, really wanted me to have this. And, I just miss her so much. I just miss her so much. And I just want this thing. And you may say, well, oh, gosh, I don't really want to do this, but, you do it. And then where's your brother in all of this? Did he have a chance to look and say, hey, mom or dad actually told me the opposite, that it was mine? Just avoiding the possibility of there being a conflict around this is what I think, changing the locks and saying why you're doing it. Look, we're just changing the locks. There might be people who have the key. I want us to be on the same page about this, and I don't want us to rush about it. I've had clients, two sisters, brother and a sister, there's one that's living in California, one that's living in Massachusetts. The one in Massachusetts has been caring for the parent for forever. They just want to move on. They just want to get rid of all the stuff. Now, all of a sudden, the California person comes in. Oh my gosh, there's so much stuff. We need to look at it. We want to value it. We want to, we want to sell things. And it's just, there's just a different perspective, and ultimately the person who's in charge has to honor and respect what the other sibling may want, but within a time frame, right? So you kind of have to manage and navigate, be respectful of the other person, but understand that there is a time, for a limited time, to kind of do this, because there are other bigger things that have to be managed and tackled, like the sale of the house, for example. There's a whole chapter in my book about the house.
There is.
Because
And,
it does get tricky.
Yeah. And I know this, there's a lot of detail we're talking about, but Anna really does spell it out well here. If you're in a different state than Massachusetts, like I am, I still think most of it's going to apply, and you can certainly ask your attorney or your accountant or your parents' attorney or accountant for clarification. And I think the communication and the documentation is going to be critical. So Kathy, yes, Anna did say you have to retitle the assets. Anna, would you explain how and why that works?
Mm-hmm. So to have a revocable trust avoid probate, the trust typically has to have ownership of that asset. And so if someone creates a revocable trust, so let's say I have a revocable trust, the Anna Byrne revocable trust, I would take my house that was owned by Anna Byrne individually, and I would have a deed transferring the property from me individually to the Anna Byrne revocable trust. And then that deed would then be recorded, and then my trust would own the property. And what that means is that when I die, my house would then be overseen by my successor trustee, who is my husband, and held in trust for his benefit until he dies. And then my son Philip would inherit the house according to the terms of the trust. So retitling basically means you're changing the ownership of the asset, the account, the house, to the name of the trust. And
you also, I think, said in the book that when your parent dies, you need to notify the Social Security Administration. And then don't you also retitle some things with a tax account number so that how does that work?
Yeah. So once you're appointed as the personal representative of the will, you are responsible for overseeing the estate of mom, right? So it's called the estate of, Molly Smith. So Molly Smith was alive. So Molly Smith has individual accounts. And so those accounts now need to be closed and retitled to the name of the estate of Molly Smith under the taxpayer ID number that was obtained for the estate of Molly Smith, because during the period of this administration, the estate of Molly Smith will have to pay income taxes on any income generated during this period of time. So you're shepherding the assets from the individual to their estate, which is listed under a separate taxpayer identification number.
Yeah. Wow, there's so many things. I do want people to look at this book. There's a lot of discussion here about the digital assets. We all have an online presence somewhere, and how do you need to know how to protect your parents' online access from getting hacked or spammed or, their identity stolen. So there's a whole chapter on that. Before we get to the end, though, Anna, I wanted to talk about the help. So we are in this state of grief. We are overwhelmed. All this is coming at us, and there's a lot to know and a lot to do. Who would you say would be the top 3 people, professionals, areas that people would need the most help in as they're going through this process?
So I would say that the number one person that you're going to need on a probate is an attorney that has experience probating estates in the state and county that your parent lived in. That's an absolute. I've had many people come to me after failed attempts to get appointment, and that's just a waste of time. 6 months trying to get an appointment and being unsuccessful is a loss of time, but also you don't get those filing fees back.
Mm-hmm.
And those filing fees in Massachusetts add up. So I would say you absolutely need a good estates attorney. And I've heard from several people who've read my book that the questionnaire that I include in my book has been very, very helpful. I think you're going to need an accountant who can file all of the required tax forms. So whether it's your parents' final income tax return, the estate's income tax return, and any estate tax returns that need to be filed. And potentially, if there are sizable assets involved, a financial advisor who can kind of help you understand, what some of the things, what your options are with respect to the investments in your parents' estate to minimize risk during the administration period. So if you have, one stock and all of the assets are in that one stock, you probably really need to talk to a financial advisor to understand how you can diversify and reduce the risk, because the last thing you want to do is start off managing mom and dad's sizable estate, and because of market conditions, all of a sudden that account is worth half or a third of what you had when you started. And guess what? Your siblings and other beneficiaries are not going to be happy about it. So definitely those 3. So a trust and estates attorney, an accountant, and probably a financial advisor.
Okay. We have a ton more questions, but we are going to have to move on. So Anna has a website, annabyrne.com, where you can, there is a contact us button there. So you can certainly contact her through that. You can also find either one of her books, The Inheritor's Guide or A Widow's Guide, on Amazon or on her website. And, I will be glad to filter some of these other additional questions that came in an email to Anna and see if she might have time to give us an encapsulated answer on some of those.
Well, unfortunately, Wendy, we are running out of time, but, some things are very state specific as it relates to the probate,
Right.
of an estate, or, even how a revocable trust is administered and whether it actually makes sense in your state. But if you're in Massachusetts, definitely feel free to reach out, and, we'll see if we can help you and answer your questions in any way we can.
Awesome. Thank you. And I just wonder, so are there any takeaways besides all of the wonderful stuff you've said to us that you think you just absolutely want to leave everybody with to think about before we say goodbye?
Yeah, so I think one thing that most people don't realize is that if you don't have a plan, there is a plan in place for you. There are laws called the laws of intestacy that dictate who's going to be in charge and who's going to get your estate if you don't decide. So if you don't do something proactively, the state will decide where it goes. So act out of love for your children and your family and create a plan.
Yes, for sure. Well, I want to thank you for what you've shared today. And I want to tell everybody about our show next week. It's going to be a very special show next week because I'm going to be in Nashville, Tennessee, visiting my son. It happens to be my birthday next week. And
Birthday.
thank you. And David, my boyfriend, has gotten us tickets to go see James Taylor and Jackson Brown.
Oh my gosh.
I know, super
Wow.
excited about that. And so while I'm there, I thought, well, you know what I'm going to do? I'm going to interview my 13-year-old granddaughter, who I took on a trip a couple of years ago, because I have this deal where I take each one of my grandchildren on a grandchild trip. And we're going to do a show on that later on. So I thought, why not interview her about what that experience was like? And she can interview me if she wants to too. So it should be a cute show next week. I'm looking forward to that. Just wanted to remind you about the Alzheimer's Walk. If you all want to sign up to be on the team or make a contribution to our Hey Boomer Walk to End Alzheimer's, that is the URL that you would use. And if you want to find out more about doTERRA, give Heidi Woody a text at 864-238-8120. So I thank you all for joining us today. I know your time is valuable, and I think this broadcast was incredibly valuable today. Thank you so much, Anna, for your time and for the books.
Thank you so much, Wendy, for having me as a guest.
You are welcome. So, hey, boomers, stay curious, remember you matter, and stay well. My name is Wendy Green, and I will see you next week from Nashville.